Is now in public session. Please note this meeting will be carried live on Sairview Channel 22, Virgin Media Channel 207, Sky Channel 574, Air Vision Channel 504 and Vodafone channels, Oireachtas TV 201, Dáil 207 and Shannon 208. Members are requested to switch off your phones or put them to aeroplane mode so as not to interfere with the recording of the meeting. All public meetings are broadcast on the channel in a replay loop over the following week. Any sound interference which may affect the broadcast is going to cause problems. So again, just to remind members who have come in late to turn off their phones. Deputy Brazel is substituting for Deputy Billy Kelleher. The meeting has been convened to consider the Health and Social Care Professionals Amendment Bill 2017. The purpose of the bill is to amend the Health and Social Care Professionals Act 2005 in order to address gaps in respect of appointing professional members to the Health and Social Care Professionals Council (CURU). It seeks to permit a registration board under the aegis of CURU to apply training and education conditions to applicants for registration who have qualified but who have not yet commenced the practice of their profession. The bill also seeks to allow for the registration of physiotherapists and physical therapists in the Register of Physiotherapists. I would now like to ask the Minister for Health, Mr. Simon Harris, and his officials to address the meeting. Is that correct? No. Sorry, I was to welcome you to the meeting.
Thank you very much, Chairman.
You can address it, of course, if you wish. As there are a number of related and proposed amendments, grouping arises. So there are 13 amendments. Amendment 2 and 3 are grouped. Amendment 4 to 6 are grouped. Amendment 7 and 8 are grouped. 9 and 10 are grouped. And 12 and 13 are grouped. I will now go to section 1 of the bill. The question is that this section 1 stand as part of the bill. Is that agreed? Section 2, that section 2 stands as part of the bill. Oh, excuse me, sorry, I'm rushing ahead. There is an amendment to section 2 in the name of Deputy O'Reilly. Deputy O'Reilly, to move that amendment?
Yes, Chair. The reason for this amendment is because...
Sorry, Deputy, just to say that you move.
I do move, yes.
Thank you.
And if I can explain, if that's all right. Yes. The purpose of the amendment, I've included it because we feel that we didn't get clarity at second stage on the legislation. Deputy Kelly and the Labour Party brought forward a bill to regulate these rogue agencies, and on the back of that, the Department of Health said that a public consultation was to begin, and sure, all sorts of hoopla was going to happen. Given that the information at the time, and also in light of the excellent work done by Ellen Coyne and other journalists, it kind of underlined the reason for us to take swift and immediate action in this regard. And so I suppose the purpose of the amendment is to ensure that that action is taken as part of this legislation, or indeed maybe the Minister has something that he might be able to give us some comfort that we need not be worried, but unless that's received, we will press it. Thanks, Chair.
Thank you, Chairman. I'm going to thank Deputy O'Reilly for the amendment, and indeed I acknowledge Deputy Kelly and his party leaders' work in this area as well. And I think this is something that all parties and groupings and independents in the Oireachtas want to see addressed. We've all been sickened and appalled by it's not even false information, just the misleading nonsense, offensive, we're not allowed to use the L word, but all of that stuff that's been told to women and people in vulnerable situations as well. I am very determined that we're going to address this, and we're going to address this by regulation. Let me just, I suppose, explain firstly why I'm not in a position to accept accept this amendment and then what we are going to do. The amendment would propose a new Section 2 to amend the Act to designate the professions of counsellor and psychotherapist by primary legislation, and it also proposes to define the scopes of practice of these professions and to include crisis pregnancy counsellings in said scopes. The Act provides that the Minister for Health may, following a consultation process and with the approval of the Houses of the Oireachtas, make regulations designating a health or social care profession not already regulated under other legislation if the Minister considers it to be in the public interest to do so and if certain specified criteria have been met, and I absolutely do consider it to be in the public interest. So in the case of counsellors and psychotherapists, we are already far advanced on this process. I'm not exactly sure what hoopla is, but we have gone to already gone to public consultation and indeed concluded that process, and my department is currently preparing regulations which I intend to bring to the Oireachtas in the autumn for the approval of the Oireachtas. The 2005 Act itself doesn't define scope of practice. This is an issue we obviously discuss in general. Instead, regulation is primarily by way of registration and the protection of professional titles. It's an offence for non-registrants to use a protected title, and recognising that scopes of practice evolve over time, and in order to ensure public protection, each profession's code of professional conduct and ethics obliges registrants to act within the limits of their knowledge, skill, competence and experience, and any breach of that code can obviously be defined as professional misconduct and can be liable to investigation, sanction up to and including the cancellation of registration under the fitness to practice provision. So in relation to the issues of crisis pregnancy counsellors or agencies and allegations that some of them have provided misleading information, my department, in addition to the regulation process, is also currently reviewing the Regulation of Information Services Outside of the State for Termination of Pregnancies Act of 1995 to establish if its provisions need to be strengthened. And one possibility would be to amend the 1995 Information Act when counsellors are regulated under this 2005 Act to prevent professionals who are not regulated by the state from providing crisis pregnancy counselling services. So, Deputy, two parts: to lay the regulations before both Houses of the Oireachtas for their approval, to regulate counsellors and psychotherapists in the autumn, and following on from that, to see if we can amend the Information Act, which obviously there's a number of other things going on in that area at the moment, to further strengthen that as well. So I can assure you that we are genuinely taking action. I know when this committee considered Deputy Howland's bill, I think it was the view of the committee and indeed the Deputy that regulation was the way to go, and we are proceeding with haste, and I will lay the regulations before the House in the autumn.
Have you any other comments?
Well, you see, as we sit here today, women in crisis pregnancies are being faced with these individuals who do not seek to give them information, who seek only to traumatise them, and it is absolutely necessary that they be regulated. I take the Minister's assurances that we will see some substantial progress from this when we resume, and on that basis I do not wish to press the amendments, but I do reserve the right to bring forward these amendments at report stage, Chair.
Are you withdrawing the amendment?
I withdraw, yeah.
Thank you. So the question then is that Section 2 stand as part of the bill. Is that agreed?
Agreed.
Section 3, the question is that Section 3 stand as part of the bill. Is that agreed?
Agreed.
Section 4, the question is that Section 4 stand as part of the bill.
Yep.
Agreed. Section 5, the question is that Section 5 stand as part of the bill.
Agreed.
In relation to Section 6, there are two amendments, Amendment 2 and Amendment 3. 3 are related. 3 is a physical alternative to 2, so 2 and 3 will be discussed together. Deputy Kelly to move.
Yeah, so move. This is a very simple amendment, basically, to go in to insert a line on or after the date at which Section 6B of the Health and Social Care Professionals Amendment Act 2017 comes into operation no later than the 31st of December 2019, so that we have an end date on this. That's the reason for the amendment. And I know that there were discussions ongoing between the Minister and various parties relating to a number of considerations in this bill. If it helps the committee, I won't be pushing the amendment today, but I will reintroduce it again at report stage should those discussions not be successful. But I'd be quite hopeful, given discussions we've had this morning, that they will. and I'll take the same attitude relating to the other four, I think it is three other amendments I have as well.
Thank you. Minister.
I'd say before answering the specific amendment, can I thank Deputy Kelly and indeed members from right across all political groupings in this House for their engagement with my department officials and with me in recent days and weeks on this important issue. I want to say at the start of this, because this will apply to indeed all of the amendments, I want to engage further with the professional bodies, with both the ISCP and the IAPT, to make sure that we can tease through any issues or concerns that people have. I say that in an effort to be constructive and helpful. I think this is an extraordinarily important piece of legislation, and it's a piece of legislation that is grounded in protecting the public, in public safety, and in empowering members of the public as they go about their business obtaining services from professionals in this state. I have every confidence in CORU as our state regulator and in the Physiotherapist Registration Board in discharging its duties as the regulator, but I absolutely want us to get this piece of legislation right. And I think, as we've discussed in recent days and weeks, the issues, I think it boils down to a very small number actually of issues where I accept that there are legitimate concerns, and what I would suggest, this House is due to go into recess at the end of this week, I would suggest that we would use the period of time between now and the House resuming and before report stage in this legislation to see if we can iron out those issues. And I know there's particular issues in relation to scope of practice, the fact that we don't define in primary legislation scope of practice, but can we provide further clarity in relation to that? And also the issue of assessment professional competence test. What does that involve? What's the criteria? Where is it set at? And again, can we provide further clarification in relation to that? So, and obviously all of that subject to the legal advices that are available to me and through the Office of the Parliamentary Draftspeople. So I just wanted to say that at the outset, because I think it will come up as I progress through each of these. In relation to this specific sets of amendments from Deputy Kelly, Howland, Brazel, Kelleher and O'Reilly. The reason I'm not in a position to accept these amendments now, but accepting or hoping you accept my good faith that my department will engage further, is that they'd actually have some unintended consequences. As I understand it, these amendments seek to ensure that the application period for recent IPTAS graduates is time limited, and a date of the 30th of September 2018 is proposed in one of these amendments. However, Section 6B of the bill already provides a stop date of the 31st of December 2019 for IPTAS graduates, and this is to allow, it's for a simple reason, it's to allow students today on the current final IPTAS physical therapy programme to graduate by the end of 2019. More importantly, these amendments would also have the unintended consequence of sunsetting provisions of Section 5 of the bill insofar as they relate to applicants for registration who have never practised their profession. So perhaps this is an issue we can engage on further between now and report stage.
Thank the Minister for his clarification and also for his openness in relation to the issues. I agree with you in relation to we need a period of time to sort out these issues, and we need to use the summer wisely, and I hope your department will actually use the summer wisely, and your officials who are with you in particular in relation to trying to deal with these issues. There are intricate issues here. They affect people's professions. We really need to be very careful that there aren't unintended consequences across the board here. We've been down the road on this, on issues similar to this before, and there has been problems. So on the basis of that, I won't be pushing the amendment. I don't fully agree with the Minister's response in relation to this specific issue, but having said that, I do accept his bona fides, and I do think it's unfortunate that these issues probably weren't teased out to the level they should have. Probably not your fault, by the way. Probably goes back to your predecessor, may I say, but
I couldn't say I couldn't.
But I know you couldn't, but we'll joke about that some other day. But I accept your bona fides. Thank you, Chair.
No, and I must say, I mean, the now Taoiseach and previous Minister for Health and myself,
I had to get you on the record on this.
Are both obviously aware of the importance of this legislation, and indeed the policy remains the same. I suppose when you have to take a policy and translate it into legislation, and with legal advices and the likes, I suppose it fleshes out a policy. And I am happy to tease through the details. And you're entirely correct, Deputy Kelly, to raise the important issue of people's livelihoods here as well, because as we're making decisions in the Oireachtas that absolutely have to protect public safety, that's what this is about, that's what Corey was about, the state regulator. We do obviously need to be conscious of the fact that there are people whose livelihoods depend on getting this right, and the whole purpose of this legislation, indeed the whole purpose of the regulation right across the range of professions, is to make sure that people are practising to the level of their qualification and experience and no further. Yep. And that's where we need to end it.
Thank you, Minister. Deputy Brazel.
Thank you, Chair. At the outset, Minister, can I just say that, you know, for me and for us in Fianna Fáil, that public safety is our primary concern in this legislation. People's livelihoods are important, but public safety will always come first and has to come
Absolutely.
first. So, in your negotiations over the summer with the bodies to try and resolve what is now two really key issues, I think that has to be taken on board. With regard to the first amendment around the closing dates, I just would like it for the record to on the meetings that I had with the department and with your officials, Minister, it was pointed out to me that it's already covered in the legislation to state that 1 year after the legislation is passed is the close-off date. And as such, then there is no need for a cut-off date because it automatically kicks in once the legislation is passed. But I would like that repeated and recorded on the record for the benefit of the organisations in the gallery to put their mind at ease on that one. And as we go through, there are other amendments. I presume we'll get an opportunity to speak on those individually as we go through. And so I'll say my comments on those issues.
So are you withdrawing your amendment 3?
I'm allowing it to go forward to report stage, and if I'm satisfied that what we're looking for here is covered, then I won't be pressing it, but I reserve my right to press it at report stage.
Okay. And Deputy Kelly, are you in relation to Amendment 2? Are you withdrawing it? Or?
Yeah, I'll withdraw for report stage on the basis of the discussions previous.
Yeah. Okay, thank you very much. We're now going to proceed to Amendments 4 to 6 inclusive. Amendment 4 is proposed by Deputy O'Reilly, 5 by Deputy Brazel and 6 by Deputy Brazel. So,
Chair, the inclusion of this amendment is to bring forward the date from 2019 to 2018 and ensure...
Sorry,
I
move? Yes,
my apologies, Chair.
and just to say myself, which I did leave out, 4 and 6 are inclusive and are related. Yeah. 5 and 6 are physical alternatives to 4, and 4 to 6 are inclusive and will be discussed together. So we're going to.
So we're taking 4 and 6 together. So it's 4 to 6.
Sorry, just to go through some procedural issues. Deputy Brazel, we didn't ask you to move your... Withdraw.
Move.
Yeah, thank you. Sorry, Deputy O'Reilly.
Chair, the inclusion of this amendment is bring forward the date from 2019 to 2018 and also to ensure the assessment of competence for applicants will be at the level of the physiotherapist qualification. I think it's important that all registrants should have the same level of professional competence to ensure that there is understanding of their role, not by themselves as professionals, they clearly do, but that there is understanding of their role and function by members of the general public. I'm mindful of the helpful suggestion made by the Minister, so I am not proposing to press amendments if they will be encompassed by the discussions that will take place in the intervening time, but I do reserve the right to press these at report stage.
Thank you.
Yes, thank you, Deputy O'Reilly. And again would suggest that we could further discuss these matters between now and report stage, but the purpose of these amendments and the reason I'm not in a position to support them today is that they would seek to bring forward the end of the application period for recent IPTAS graduates from December 2019 to September 2018 in the case of recent such graduates, and to September 2019 in the case of current students who will graduate in 2019 from the final IPTAS programme. The amendments presumably intend that those who have already graduated since 2013 will have a one-year application period that will commence in September of this year. However, as it looks likely that the bill will not be enacted until the autumn at the earliest, that September 2018 deadline is now out of sync with the intention of the bill. The bill sets the application period for recent IPTAS graduates, in other words those who graduated since 2013, and for current students graduating in 2019 at the 31st of December 2019. And this will require current students to qualify and to apply in the 1 year, and I do think that's a reasonable end date in the circumstances. I also think that introducing different application periods for different post-2013 graduates could complicate matters further. The bill already provides for a separate 1 year application period for graduates who qualified before 2013 and who demonstrate practice under the title of physical therapist for a period of 2 years in the previous 5 years as well. In relation to the competence test that you raised, and I referenced in my own opening remarks, this is something that I hear as a legitimate issue that people want to see further teased out, and I'm happy to do that during the process of our engagement before our report stage.
Thank you, Minister. Deputy Brazel on amendment number 5 and 6.
Yeah, this really centres around the commitment that was given by the previous minister around restricting the practice to musculoskeletal for physical therapists. And whereas physical therapists will, that is the area and where they practice anyway.
Amendment 7?
Yes.
Sorry to interrupt.
Wait, you're on amendment 5 and 6?
Well, I've nothing further to add to Deputy O'Reilly's comments on the previous issue. It's that's around dates as well. And
yeah. That's right. Sorry.
Okay.
Are you happy, Minister?
I am.
Okay.
Deputy O'Reilly, are you withdrawing the amendment number 4?
Yes, on the basis of the discussion that we just had, with the right to bring back a report.
And Deputy Brazel, are you withdrawing? Oh, sorry, to move your withdrawal?
I move my withdrawal, Chair.
Okay. Yeah. Sorry, it's confusing. Deputy Brazel, are you pressing these amendments?
Yes, but again on the basis that
you're withdrawing them on the basis
they can be reintroduced at report
so
stage.
Can you move?
I so move.
Thank you. And withdraw. Thank you.
And then 6 to move. Amendment number 6, Deputy Keller, Deputy Brazel to move.
And to move amendment 6.
Yes.
And withdraw.
No, I want to talk about section 6 now first before we do anything further. If that. Oh, sorry.
Yeah.
Okay, 6. I move and withdraw.
So we're now going to move to Amendment 7 and Amendment 8, which are going to be taken together. Amendment 7 is in the name of Deputy Brazel, and number 8 is in the name of Deputy O'Reilly, Deputy Kelly, and Deputy O'Connell. Can you move Amendment 7, Deputy Brazel?
I so move. Okay, again, this issue around scope of practice, and I just want to read from a letter sent by the previous minister to the ISPC dated, I think it was July of last year. To ensure public protection, the Board's Code of Professional Conduct and Ethics will oblige those registered under these provisions to act within the limits of their knowledge, skill, competence and experience. In other words, the new registrants will be required to confine their practice to musculoskeletal therapy. So that is the commitment given, and that is what the ISPC are looking to be included in the legislation. Now, we've had meetings and it's been explained that the scope of practice is never defined in primary legislation. However, it is very important that the public who are seeking any form of therapy are very clear in their mind as to the exact level of competence to the person to whom is treating them. And when a person has a plate or a professional has a plate up on their wall advertising a service, it's very important that the public know exactly what that person can and cannot achieve for them. So from that point of view, the legislation, in my opinion, isn't clear enough, and certainly the ISPC and indeed the IAPT need reassurance that this legislation clearly defines what scope of practice they can operate under, and when there's a competency level assessment being done, to exactly what level of this competency assessment, who will be carrying it out, who will have an input into it, and what assurances can be given to both bodies that the people who ultimately get registered are able to provide a safe service to the public. So that's the reason for this amendment. There was a clear commitment given. It doesn't seem to be clear in the legislation that what has been promised has been followed through on, and there is a need to do a substantial amount of work to get this issue resolved and to get both parties with an interest in this legislation satisfied.
Thank you very much. Minister.
May I thank Deputy Brazel for his informed contribution on this, and may I at the outset make it absolutely crystal clear, because I don't mind robust debate, and I don't in any way refer to you, Deputy Brazel, in this regard, but I don't intend to allow myself to be in any way misrepresented. The policy as set out by the then Minister Varadkar is the policy that I am putting into law, which is that people will only be able to practice up to the level of their qualification. And if you lack a qualification beyond musculoskeletal, you will not be entitled to practice. And if you do practice beyond that, the sanctions that will apply to you will be the same sanctions that apply to all other professions who've been dealt with through our state regulatory body, CORU, up to and including being struck off the register and losing your ability to actually have a livelihood. So the sanctions are quite serious. However, having said that, I think the Deputy makes a very fair point, which is about the need to provide that further clarity, and I'm very happy to undertake to do that to both bodies, to both the ISCP and the IAPT. I'm very satisfied that we should have a further engagement between my department and both bodies at the threshold at which the competence test is set, because I think that is an issue that has been raised by everybody, if you like, over the last number of weeks, and I think that should be re-examined, the threshold at which the competence level is set, because this is, you're entirely right, about public safety, and I think both bodies and every member of this Oireachtas supports that. In relation to the issue around scope of practice, as I've already said, and indeed as you've acknowledged too, we don't include scope of practice in primary legislation, and for quite good reason. Professions evolve, and if we have a situation whereby we have to return to a piece of primary legislation, all of us knowing how arduous and time consuming that can be and the length of time it can take to get that addressed with, that wouldn't be in the interests of the public. So, however, recognising that scopes of practice do evolve over time, but also recognising the need to provide public protection, each profession's code of professional conduct and ethics obliges registrants to act within the limits of their knowledge, their skills, their competence and their experience, and any breach of the code is defined in the Act, is defined in primary legislation as professional misconduct and would be liable to investigation and to sanctions up to and including cancelling of registration under the Act's fitness to practice provision. So the primary legislation does envisage what to do if somebody exceeds their scope of practice, but scope of practice is defined in the profession's code of professional conduct and indeed ethics as well. The Physiotherapist Registration Board has such a code, and it will apply to those registered under those temporary provisions as well as to other registrants. Such practitioners, or indeed any physiotherapist without the up-to-date skills in cardio or respiratory and neurological therapists, will be obliged, I want to be very clear on this in the record of this committee, will be obliged to confine their practice to musculoskeletal therapy or face investigation and sanction. So that is included in both the combination of the legislation and the code of conduct. However, I do want to say this because I want to be constructive on this, and I want to make sure that any misgivings, concerns, lack of clarity is ironed out between now and report stage. And I would suggest that if members of this committee were minded to do so, I would certainly have an openness to doing so, subject to our legal advice and our drafting, to look at if we could come forward with some amendments at report stage, and I'd be happy to come forward with amendment at report stage to provide that a code of professional conduct and ethics adopted by a registration board shall require registrants to act within the limits of their knowledge, skill, competence and experience. So this would copper fasten that code in primary legislation and would legally require all registration boards to include this provision in their codes while stopping short of defining the detail, which is something that if you accept, and I think we largely accept, that I can't define the scope of practice in the primary legislation, if I can underpin in primary legislation the code of professional conduct and ethics adopted by the registration board and the requirement of all registrants to adhere with that, I do think that would go some way to providing further clarity. So I'd be, again, happy to have this conversation between committee and report stage.
Would it be possible to have those proposals or draft proposals maybe in place and then meet with the respective organisations so that they'd have something to...
I would intend to engage, that's my intention, to engage on all these matters before report stage.
Thank you very much, Minister. And in relation to Amendment 8, which we are taking with Amendment 7, Deputy Kelly, Deputy O'Reilly and Deputy O'Connell.
I'll withdraw on my behalf anyway. There's others, but Kate and Louise, but on my behalf to save time, we'll withdraw. I think a lot of these issues are interconnected now. So on the basis of what the Minister is saying and the spirit, we'll withdraw, and if we have to put them in a report stage. And obviously, I understand that, Minister, as part of this process, based on what Deputy Brazel has said there previously, what will happen here is there will be a consultation process with both sides, that you'll come up with some draft conclusions, and that on the basis of that there will be discussion trying to come to an agreement whereby then eventually through this process amendments will be put forward, and those amendments we'll agree on, and if we don't agree on them we can put forward, we'll obviously push our own amendments. Is that understood? That's
understood, with the understanding, as I've outlined in my answer, that there does need to be, when you have CORU, a state regulator in place for a range of professions, a consistency across the board. So any changes that we look at making to, say, a code of professional conduct, we'd apply to all of the professions.
Okay. Yes. So on that basis I withdraw and reserve the right for report stage.
Thank you very much, Deputy Kelly. Deputy O'Connell.
Just briefly, if I may, I'm with everyone on this. I suppose my own concerns are in line with everyone else's, that it's public safety that I see as the priority here, and that we should, I suppose, as legislators seek, that should be our primary aim, and that also we have the highest possible standards when it comes to professional professions, and that the regulatory process is fit for purpose as well. It's just, I totally get what you're saying there, Minister, and I look forward to the draft proposals, but I would always, I suppose, be conscious of retrospective sanctions when somebody's health is being dealt with. So to regulate, so if somebody has an adverse event, that then it's through a sanctions process that the person who is responsible for that is dealt with. But like that, these things can be worked around, that we can work around through the Code of Practice and the Code of Ethics, and hopefully that will help us all here, because really what we're all at is trying to make sure there's no negative unintended consequences for the public or for people who are working out there and have their practices in whatever jobs they're doing. So I'm with everyone on that, but just to put that on the record here today. Thanks, Chair.
Thank you, Deputy O'Connell. Deputy O'Reilly.
Chair, on the basis of all of the foregone discussions, I'm happy to withdraw the amendment, but I do want to put it on record as somebody who has represented people in a similar forum in relation to fitness to practice. It is absolutely imperative that the people who are practising under these regulations and under this legislation are given as much clarity as possible, because they need to understand themselves, as well as this is a public safety issue, we know that, as well as members of the public, but to be fair to the people who are practising, regardless of which profession they are under, to be fair to them, we need to be in a position to give them the maximum amount of clarity. And on the basis of the suggestions made here today, can we take it that this is going to be done while we are, that these discussions will take place while we are in recess to I mean, obviously subject to everybody's calendar and all that, but that every effort will be made to have these issues resolved before we resume in the autumn?
Yes, absolutely. And may I just say, I mean, the Deputy is right, we're all at ITM, so it's not in any way trying to suggest someone's livelihood outranks public safety. It certainly doesn't. Public safety is what this legislation is about, it's what the CORU process is about. Acknowledging that that is priority number one, we also must, in picking up on Deputy O'Reilly's point, acknowledge that there are people out there who are validly qualified to carry out musculoskeletal therapy. They're known as physical therapists in this country. This is the anomaly, I suppose, that has arisen. They are not validly qualified to carry out other issues that physiotherapists carry out, and there does need to be a very clear understanding and distinction and difference in that. But in relation to the issue of sanction, I mean, it's, without being in any way flippant about an important issue, it's not possible to sanction somebody unless they have done something wrong. I mean, that's the way we regulate every profession in this country. But the risk of sanction is extraordinarily high. The idea that somebody would purposefully go out and actually risk their livelihood, their business, their profession, their reputation, is a pretty substantial one. But I do think, and I am coming forward today with a proposal in an effort to be helpful, to go further in this area than we've gone before in terms of the regulating of professions, by looking at if we can underpin that professional code of conduct in primary legislation. My officials will work on drafting some proposals. We'll engage with the ISCP and the IAPT, and then with members of this committee before report stage.
Thank you very much, Minister. Any other comments on this?
Can I,
so in relation to...
Sorry, Michael.
Sorry.
Chairman, can I just add, just in my contribution, I meant to make two specific references that I would like taken into discussions that will follow. Firstly, the issue around people who have qualified but not practiced. I think there needs to be a very stringent registration and competency assessment done on those individuals who for a number of years, although qualified, haven't practiced and are looking to register now under this legislation, and that has to be tied down and kept very, very tight. The second issue then would be there are people outside of IAPT qualification and outside of ISPC qualifications who are practicing and who will look to come in under this legislation. And again, from an absolute public safety point of view, and there can be no issue around livelihood here. This is public safety. For those people, the competency assessment has to be to the highest standard and has to be to the satisfaction of both organisations.
Thank you very much.
I fully agree with the Deputy on that, and just to, I suppose, for the record as well, the issue of those who are qualified but have not practiced is a standard provision across all of the professions regulated by CORU. So again, in some of the conversations, I suppose, because there's been a lot of focus, understandably, on the issue of physiotherapists, I suppose the view could be that it's particular to this profession. It's not. It's the same provision that applies to speech and language therapists and all other professions where somebody has qualified but not practiced, and you're entirely correct. It needs to be extraordinarily stringent, and will be. And the second point, again, you're correct, and it's how the level at which you set the threshold for the competence test is absolutely something that I think is a concern shared by both organisations, myself and I think members of all political parties and groupings here. I would make the point that there's people practising today in this country without having to go through such a test. This legislation will make that no longer the case, and I'm happy to talk to you about the threshold of that test.
As long as they can call themselves physio or physical therapists, I don't think any organisations are.
And the only people who can call themselves that will be the people who pass a competence test. And I think the view from reading and talking to people is that the threshold at which that test is set, and I'd be happy to engage with both organisations on that.
Thank you very much, Minister. So then, in relation to 7, just for the technicalities, Deputy Brazel, is that amendment to be made, or are you withdrawing the amendment?
I would withdraw on the basis that I can reintroduce it. It can be discussed again at report stage.
And in relation to Amendment 8, I just need one of the 3 proposers to move that amendment.
Move.
Thank you. And is that amendment to be made? Or are you withdrawing that amendment number 8?
Withdraw.
Thank you. The question is then that section 6 stand as part of the bill. Is that agreed? We now move to section 7 of the bill, and there are a number of amendments. We are taking 9 and 10 together. Amendment 9 is in the name of Deputy Brazel. Do you move that amendment, Deputy?
I do. I think I probably have already spoken on it.
Okay.
Yeah.
Well, just for the technical point of view, yeah. And there is amendment number 10 in the name of Deputy Kelly and Deputy O'Reilly. Do you move that amendment?
Move, but same thing. It's been spoken about.
Okay. So the question is in relation to Amendment 9. The question is the amendment made.
Okay. So in relation to Amendment 9 in the name of Deputy Brazel, is that amendment to be made, or are you withdrawing that amendment?
I'm withdrawing.
Thank you. and in relation to Amendment 10 in the name of Deputy Kelly and Deputy O'Reilly. Is that amendment to be made?
Withdrawn.
Withdrawn. And moved. Just technically again, it's moved? Yeah, thank you. Thank you. So now we are going to proceed to Amendment 11, which is also in relation to Section 7, and that amendment is in the name of Deputy Brazel, Deputy Kelly, Deputy O'Reilly and Deputy O'Connell. Would you move that?
But we'll withdraw subsequently.
Deputy Brazel, Deputy O'Connell and Deputy O'Reilly. Agreed. Thank you. So that amendment is withdrawn, and we are now moving to the last two amendments, which are Amendments 12 and 13, and they're going to be taken together. Again, in Section 7, Amendment 12 is Deputy Brazel to move.
Move.
And number 13 is
leave. 12 and 13 are related and will be discussed together.
Okay, sorry, 12 and 13 are related and will be discussed together. So, Deputy Brazel?
Again, we've discussed, this is in relation to people without qualifications.
It's the scope of practice discussion again.
Registered pursuant of subsection 4A shall be required to confine their practice to musculoskeletal therapy. Is 12?
Yeah, well, I mean, we've discussed it, so I'm not going to repeat what I've said.
Okay.
The same.
So, that the amendment be made or withdrawn?
I move the amendment and subsequently withdraw it.
Thank you. And Amendment 13 in the name of Deputy Kelly, O'Reilly and O'Connell. Move that amendment?
We move the amendment and we withdraw.
We move the amendment and we withdraw. It's
Thank
very
you
easy stay in here, Chair.
Thank you very much. So the question is that Section 7 stand as part of the bill. Thank you. Section 8, yes. That Section 8 stand as part of the bill. Is that agreed? Thank you. And the last section, that Section 9 stand as part of the bill. Is that agreed?
Agreed.
Thank you. So the title, say that this be the title of the bill, an act to amend the Health and Social Care Professional Act 2005 and to provide for related matters. Is that agreed? As consideration of the bill has been completed in accordance with Standing Order 87, the following message will be sent to the Clerk of the Dáil. The Select Committee on Health has completed its consideration of the Health and Social Care Professional Amendment Bill 2017 and has made no amendments. Is that agreed? Thank you.
Agreed.
Minister and your officials, I'd like to thank you for attending the meeting this afternoon and to thank the members of the committee for considering the bill. The Select Committee is now adjourned sine die. Is that agreed? Agreed.
Finally, Chairman, before we finish up, can I say, in light of the cooperation from all members and with the department, that now that we've got it through committee stage, that the final passage of the bill would proceed as quickly as possible, because both organisations are extremely anxious to get this over the line. It doesn't finish up as much other legislation has, unfortunately, in the last 12 months, gathering dust somewhere, that we get it done and that the negotiations that are required to take place in a very prompt manner. Thank you.
Chairman, I agree with that, and we'll do everything at an official level here to ensure that that discussion takes place before the Dáil recommences. Thank you very much.
Thank you very much.